Good afternoon. I want to thank Dr. Krishna Prasad for giving this opportunity for me to interact with all of you. I am having a post of additional member secretary in Karnataka State Mental Health Authority, which is expected to implement this Mental Health Care Act 2017. And I plan to describe what is the relevance of this Mental Health Care Act 2017 to the people with mental illness and their caregivers and their family. And at the end of it, I will be willing to make, I'll be happy to answer if there are any clarifications, questions. Shall we start the PPT? Here, I have not really put all the sections of the Act. I have selected few relevant sections and subsections which are of relevant for the audience. And I would request you to go through the original Act for comprehensive understanding. We must know that this Act has come up with a very specific objective to provide for mental health care and services for PWMI, people with mental illness, and to protect, promote, and fulfill the rights of such people, and also to ensure health care, treatment, and rehabilitation and integration to the community. This is the objective which is stated within the Act, which underlines this point that the whole Act aims to provide mental health care and services to everybody with PWMI in our country. There are various new concepts which are introduced in this particular Act. You may be familiar, advance directive. Admission is supposed to be a least, in the sense, he should be given a least restrictive environment to live with. And there is a concept of nominated representative, mental health review board, supported admissions, and rights of person with mental illness. Advance directive, I will be repeating it again later. Advance directive is a document where the patient indicates how he needs to be treated, how he doesn't want to be treated. And places where we admit patients, we should ensure that it is as least restrictive as possible. We cannot lock them up and keep them away from rest of the people or community. And they have the right to nominate their own representatives. There is a separate court for statutory body, legal body, to supervise how the psychiatrist is treating the mentally ill, and the concept of supported admission, where with the consent of the family members, a patient can be admitted, and rights of person with mental illness. Person with mental illness have been given multiple rights in this particular Act. First, I feel all of us should know what is the definition of mental health establishment. So it's any place, any health establishment where person with mental illness are admitted, they reside, and they are taken care, they are provided treatment, they are kept for convalescence or rehabilitation, either temporarily or for long time. Any place, including places for dementia, places for de-addiction, or any psychiatric hospital, all those are considered as mental health establishment. And mental illness.
Just remove the video.
Sure. Mental illness, the definition includes any condition which is associated with, other than what we generally understand as mentally ill, any condition associated with abuse of alcohol and drugs also. However, it doesn't include mental retardation. Psychiatrists have been specified as to how to determine mental illness, as to what standards should be used and how it should not be diagnosed, how it can be diagnosed, and all that has been mentioned in the Act. This is another new one, which mandates the psychiatrist to assess the capacity to make decisions of the persons with mental illness. As the first line says, every person, including a person with mental illness, shall be deemed to have capacity to make decisions regarding his mental health care and treatment. Irrespective of how we feel about his severity of illness, every person is deemed to have that capacity. And that is measured by whether he can understand the information provided to him, whether he can appreciate any reasonably foreseeable consequences of the decision and whether he can communicate. Now, all the mental health care about for a mentally ill person has to start from this, that whether he has the capacity to make decisions or not. And then this legal document, advance directive. Each person with mental illness has the right to make this advance directive. He can indicate in what way he wishes to be cared and in what way he doesn't wish it to be cared, and who are his nominated representatives. This advance directive can be made on a plain paper with a witness. A patient can write down all his preferences. This should be registered with Mental Health Review Board, and this Mental Health Review Board will announce this on an online register. Whenever a patient with mental illness approaches a hospital for treatment, the doctor is supposed to check what advance directive this particular patient has made, and doctor is supposed to follow that advance directive as a preference. So the psychiatrist shall give treatment in accordance with the valid advance directive. However, if there are situations where the doctor feels or the family feels that this particular advance directive is not a proper one and is irrational, there is an opportunity to approach the board and get it corrected also. A medical practitioner or mental health professional shall not be held liable if there is any unforeseen consequence on following valid advance directive. And a mental health professional shall not be held liable also if he is not following an advance directive, if it is not been given a copy of the advance directive. So this is the concept advance directive which is given to the people with mental illness. Now, next concept is this nominated representative. Here again, each person with mental illness in this order shall be deemed to have the nominated representative. For example, if I nominate any of my friends as a nominated representative, overseeing my family, he will be the official nominated representative for me. If I have not made any such preference, obviously a relative will be my nominated representative, or else a caregiver will be my representative. If I have not indicated anybody, then the Mental Health Review Board will appoint one person as a nominated representative for my care. For minors, the legal guardian will be the nominated representative. And this nominated representative will be indicated in the advance directive the person makes. Now, the duties of the nominated representative are knowing the person personally and helping him to make treatment decisions and seek information about his diagnosis, or ensuring that he gets rehabilitation and discharge. All the events that happen during admission, this nominated representative will be acting on behalf of the patient. Now we shall go into the very important part of this Mental Health Care Act, rights of person with mental illness. A person has a right to access mental health care. Any patient in this country has a right to access mental health care. He has a right to live in community. He has a right to be protected from cruel, inhuman, degrading treatment. He has a right to equality, non-discrimination. He has a right for information, right to confidentiality, right to access medical records, right to personal contacts and communication, right to legal aid, and right to make complaint about deficiencies. I'll be briefly explaining each of these. Personally, I feel this is the most important right given to people with mental illness in this particular act. Every person shall have a right to access mental health care and treatment, which means and which ranges from so many different types of services: outpatient service, inpatient, halfway homes, sheltered accommodation. Sheltered accommodation means accommodation facility where a person has a right to go and stay. He can continue his personal life staying there. He can have food there. He can actually go out, earn money, and live his life. That particular setup is called sheltered accommodation. Supported accommodation is where a person is living in the residence, that is the owned, either owned or rented home where he prefers to stay, and he will be supported through various types of mental health services provided at the doorsteps. That is the concept of supported accommodation. Hospital and community-based rehabilitation, support to family of people with mental illness, home-based rehabilitation, child mental services, old age mental health services. The Act has mentioned all these services should be provided and each patient has a right to access these. And these should be services run or funded by the government. This is what Act mentions. And mental health services should be of affordable cost, of good quality, in sufficient quantity, accessible without discrimination. All those qualifications have been given. And government is also supposed to integrate mental health services into general health services. That means any general hospital should be providing psychiatric services, and the person in all ways, in whatever way it is necessary, should be supported to live in community with their families. That's what the Act mandates. It also mentions that if a person is staying in a place where there is no access to mental health care, he can go to a place whichever is accessible, and that has to be reimbursed by the government. The cost of the treatment or the travel cost will have to be reimbursed by the government. For people with below poverty line also, they must be given treatment at government hospitals is what is mentioned. So in our country, many a times access to mental health care itself was difficult, and this Act has made it mandatory on the part of the government to provide all this with them, to give necessary budgetary provisions also. The next is right to community living. Generally, the people with mental illness in many states will be put up in mental hospitals for many years, many months. Many a times the hospital administration loses track of the family members. So they end up staying in the hospital for decades together. This Act says that each person with mental illness has a right to stay in the community, live in the community. And it also mentions that government shall provide support, including legal aid, to exercise his right to family home in case there are situations where family doesn't want this person to come back and he has a right to stay within that family. Then the Act says that government should provide the legal aid to help him to get back to his family. Right to protection from cruel, inhuman, and degrading treatment. We are aware that many a times the mental health establishments will be neglected, hygiene will be bad, our sanitary condition will not be good, and people with mental illness will be degraded, physically abused, verbally abused in many other ways. So this Act says all these cannot be done anymore. They should be given proper clothing. If they work, remuneration to be given, food and articles of personal hygiene has to be provided to them in mental health establishments. Right to equality and non-discrimination. Generally, people with cardiac illness, kidney illness, or any other medical illness will be given high priority in any hospital. This Act says that people with mental illness should be considered equal to people with physical illness. Emergency services, ambulance services must be available to them, just like how it's available to any other patient. And this part is very important, that even medical insurance, nowadays there has been the Government of India advisory to all the insurance companies that even psychiatric patients or mentally ill should be given the medical insurance. So such provisions have been made and it's operational now. Person with mental illness has a right to seek information about why he is admitted and what is the treatment plan and what's going to be done with him and all these things. Right to confidentiality. Lot of the mental health patients could have many personal issues or family issues which will have to be kept confidential. Restriction or release of information in respect of mental illness to media. Nowadays, really media has barged into all our personal life. As far as a person with person with mental illness is concerned, that cannot be released to media. Right to access medical records is there. Right to personal contacts and communication. A patient has a right to see somebody, has a right to refuse to visit somebody. The mental health professional or the psychiatrist cannot really force the patient to meet people whom he doesn't want to meet. So this is another right provided by the Act. Right to legal aid, as I already mentioned, that they are entitled to get free legal aid, and right to make complaints about deficiency in the provision of services. If I'm running a hospital and if my patient has a grievance about the way I am treating him and the services I have provided, he has a right to complain to the mental health review board against me. Now, the government has been given various duties. It is supposed to promote mental health and make attempts to prevent mental illness, reduce suicides and attempt suicides in the society. It's supposed to increase awareness about mental health and illness and reduce stigma. Government is supposed to increase the human resources available to deliver mental health interventions and to train all medical officers in PHCs. These are the different duties given on the government. There are various administrative setups which is mentioned in the Act. One is Central Mental Health Authority. It is a board, or it's an authority, it's a group which consists of medical people, administrators, patients, people represent patients, people representing patients of mental illness, and people representing caregivers, people of representatives of NGO who are working in mental health field. This particular body will be supervising the mental health activity throughout the country. Then this state mental health authority, in which I am additional member secretary, this is also at a state level. It's a body which has about 30 members in our state, which contains multiple administrators, which contains an eminent psychiatrist, psychologist, social worker, mental health nurse, and representatives of patients, representatives of caregivers, and representatives of NGOs. All these people will be included into this. And each of these, for example, is Karnataka State Mental Health Authority. Our functions are to register mental health establishments, to register mental health professionals. And if there is any complaint from any patient about, or any patient or anybody about a mental health establishment, if there are any abuses or any problems in treatment, that will be forwarded to mental health authority, and we will have to investigate and find out and take necessary punitive actions if there are illegal things which are done. Now, I request the audience to be aware that each place which tries to treat mental health people with mental illness needs to be registered. They have to be registered under their own state mental health authority, and there have been steps of registration that is prescribed in the Act. Basically, what it says is each mental health establishment needs to register, and it has to maintain some amount of minimum standards. That minimum standards will be issued by the state mental health authority. And once that minimum standard is fulfilled, it is satisfied that yes, this authority, when this establishment is fulfilling the minimum standards, then only the registration will be done. Otherwise, all places, if they have not got registration, that indirectly also means that they don't fulfill the minimum standards. So I request the audience that if there is any situation of getting admitted and get treated in any hospital, please check whether that particular hospital is registered under state mental health authority or not. The next concept given in this Act is audit. Every 3 years, each of the registered mental health establishment will be audited. There will be a team which will be sent by the mental health authority, and the patients, caregivers, and representative NGOs have been provided the opportunity to be a part of this audit team. So once in 3 years, each MHE will be audited, and if the minimum standards are not maintained, the registration actually can be cancelled. If there are complaints against any mental health authority, mental health establishment, the complaint goes to the authority and an inspection will be conducted. And in this particular thing also, representatives of NGOs who are working in mental health field will be part of the team. And if it is true that the human rights or the treatment guidelines have not been followed in that particular establishment, that establishment will be punished. Section 72 says it is the duty of the establishment to display information, the contact address and the phone number of the mental health review board, and it will also provide necessary forms to apply to the concerned board to give free access to make telephone calls to the board regarding the review of admission. If a patient is admitted and he is not happy, the MHE is supposed to give him the details as to where he can contact to get his grievance addressed. This is another concept, a newer concept in our country. Each state is supposed to initiate, state authority is supposed to initiate mental health review boards. Please look at the composition of the review board. It will have a district judge or a retired district judge as a chairperson, and it will have representatives of the district collector or commissioner. One psychiatrist will be there, one medical practitioner will be there, and two of the people with mental illness or caregivers or NGOs working in the field of mental health. This is a new addition. It is a quasi-judicial body which can actually work like a court for the field of psychiatry, mental illness. And there are a lot of guidelines as to how exactly this mental health review board should function. Please be aware of the functions of this board. It can register, it should register, it can review, alter, modify, or cancel an advance directive. It will appoint nominated representative to each patient, including homeless people with mental illness, if there is no appointed nominated representative already. It will receive and decide on the application of PWMI or his nominated representative against mental health establishment regarding sections 87, 89, 90. This is admission of a minor, admission of a person for up to 30 days, and supported admission of a person up to 90 days. And this board can receive and decide on application regarding section 25, that is accessing medical records, to receive and decide application regarding deficiency of care, and to visit, inspect prisons and inquire about the health services available in the prison. This is a function of the mental health review board. So now there is a new body which is accessible or made available for all people with mental illness to submit their grievances if there is any problem about the treatment. Now, there are few specifications as to how the admission and discharges are made. Previously, in the previous act, there was something called voluntary admission. Now it is called as independent admission. As I already mentioned, every patient with mental illness is deemed to have capacity to decide his own treatment. Whether he needs to take treatment or not to take treatment, he is deemed to have the capacity. And each person with such a capacity, he can get admitted at his will and he can get discharged at his will. That is the concept of independent admission. So a patient can walk into a hospital and declare that I have such and such a mental illness and I want to get treatment as an inpatient, and he can get admitted. So in this, none of the family members or anybody is necessary. This is one concept. However, the doctor will have to ensure that person has mental illness of severity requiring admission. A person is likely to benefit from admission, and person has understood the nature and purpose of the admission, and he has requested out of his free will. Those are the conditions that a psychiatrist will have to get convinced to admit. That independent patient may get himself discharged. That's mentioned here. Now, as far as admissions of minor, as we are all aware, the legal guardian will be the nominated representative. In such a case, two psychiatrists will have to certify that this minor has a mental illness with severity requiring admission, and admission is in the best interest of the minor, and the mental health care cannot be fulfilled unless this child is admitted, and all community-based alternatives have failed. So all these conditions have to be fulfilled before admitting a minor. Now, as it's already mentioned, an independent patient at his own request can get himself discharged. Section 89. Now, this concept of supported admission, where a person doesn't have capacity to make treatment decisions. I said that is the first thing that will have to be evaluated with each patient, whether he has capacity or not. When we find that a person doesn't have capacity to make treatment decisions, he will have to be admitted under this section. And this admission will be up to 30 days. The nominated representative will have to make an application to the mental health professional. Then one psychiatrist and one mental health professional, that means two professionals, will have to certify that this patient needs admission because he had recently threatened or attempted to cause bodily harm to himself, or he had behaved violently towards another person, caused fear of body harm to another person, or has shown inability to care for himself, or to such a degree that he is harming himself. These are the conditions on which a patient will be admitted. The diagnosis doesn't matter here. The family members' opinions does not matter here. So psychiatrist or the mental health professional will have to get convinced that these three conditions are met. Only then admission will be made. And under this, the patient will be kept up to 30 days. The next admission will be under section 90, which means again, similar condition like before, high support need admission, and where the patient can be kept beyond 30 days. Again here, the nominated representative will have to make an application. And here, two psychiatrists will have to independently examine the patient and conclude that this patient has consistently over time has threatened and attempted body harm to themselves, or consistently behaved violently towards other person, and has shown inability to take care of himself. Under these conditions, a person can be admitted. There are various subsections which specifies different steps that has to be done under this particular section. Now, this is another important thing for a caregiver, that if there is an emergency, what to be done? Under section 94, it states that any medical treatment, including treatment of mental illness and transport of person with mental illness to nearest mental health establishment, it can be provided by any registered medical practitioner, which means MBBS doctor, a physician, or anybody can give this immediate treatment, either at a hospital, mental health establishment, or in the community, subjected to informed consent of the nominated representative, where it is immediately necessary to prevent death or irreversible harm to the health of the person. A person has been inflicting serious harm to himself and others. A person causing serious damage to property belonging to himself or others due to mental illness. And this section mentions that the period is up to 72 hours. That means to say, any patient without his consent can be treated with the consent of the nominated representative in any place only up to 72 hours. After that, either he will have to be treated as an independent patient, or he will have to be treated as section 89, that is supported admission. Those rules will have to be followed. There are few prohibited treatments under this act: ECT without anesthesia, ECT for minors, and chaining any person, and sterilizing people with mental illness, psychosurgery without consent. All these are prohibited. Even when a patient, for whatever reason, to be restrained, this particular act says what are the steps to be followed, and every month each hospital or each psychiatrist will have to send a report to the mental health review board as to how many patients were restrained in this particular month, and we have to maintain records of how many times and how long each patient was restrained. There is a section to direct the discharge planning, research, whether we can do research on people with mental illness. This section says steps of the guidelines are the steps that has to be followed. This is another important thing. There have been given very specific duties for police officers in the respect of persons with mental illness. Every officer in charge of police station has a duty to take under protection any wandering person in that particular jurisdiction. Any wandering person with mental illness, police officer is supposed to take charge. to take under protection any person whom the officer has reason to believe to be a risk to himself and others by reason of mental illness. And this person can be at home. However, if a person is at a risk to himself or because of reason of mental illness, a police has a duty to intervene. And persons who are taken to protection like that will have to be within 24 hours taken to public hospital, that is government hospitals, and the doctor in charge of the government hospital is supposed to evaluate whether he needs psychiatric care or not, and the time given is 10 days. Within 10 days, some decision has to be made. If he doesn't have mental illness, he will have to be sent home. If he has mental illness, he will be put into mental health establishment. Every officer in charge of the police station who has reason to believe that a person residing within limits of the police station at home is being ill-treated or neglected by the family, he can report the matter to concerned magistrate. Many times we come to know that some particular family is ill-treating or neglecting a person with mental illness. Now, this act says the police has the authority to intervene in such situations. Any person who has reason to believe that PWMI is being ill-treated, neglected by any caregiver, they can also report to the concerned police officer. Means to say, if we find that in our neighborhood a genuine psychiatrically ill patient is there and family is not taking care of him, we can actually report to police officer to take charge of that situation. A magistrate can order such people to be brought before him and then to be admitted into government mental health establishment. There have been acts, section about how to treat people with mental illness in the prison. That may not be relevant here. If for whatever reason, a judicial process is going on, say regarding a property matter or regarding any particular complaint or regarding any dispute, and if there is a claim that one of the party is mentally ill, now the court is supposed to refer the matter to the mental health review board. I have already described what is the composition of the mental health review board. So each case of mental illness which comes before the court will have to be referred, and the mental illness will have to be certified from the mental health review board now. This act also mentions if anybody runs hospital without registration, from 5,000 rupees to 5 lakh rupees penalty is there. And for any mental health professional who is working in an establishment which is not registered, he can be penalized up to 25,000 rupees. Any contravention of the various sections of the Act and the subsequent rules and regulations, they can be even imprisoned up to 2 years. That is the punishment for under this Act. Now, this is another important section in this Act. In situations of attempted suicide, previously the patient a police case would be registered and police would get intervene into as to why this particular criminal act of suicide has been committed. Now it is said that any person who is attempts to commit suicide shall be presumed, unless proved otherwise, to have severe stress, and he shall not be tried. Means to say, no police case, and he cannot be punished under the section 309 of IPC. And also, government has the duty to provide care, treatment, and rehabilitation to a person who has attempted suicide. State Mental Health Authority has right to make registration regulations. Now, there is a separate rule with the title Mental Health Care Rules, Rights of PWMI, people with mental illness, in 2018, and this has been made by central government, which actually mandates each state to start halfway homes, to provide sheltered accommodation, supported accommodation, hospital and community-based rehabilitation. And in case these services are not available in vicinity, reimbursement of the cost of treatment by the chief medical officer of the district. So there is a separate set of rules made by central government. Central government, Central Mental Health Authority has also issued these mental health care regulations, where it sets minimum standards for registration. I said each mental health establishment, mental hospital will have to be registered, and these regulations prescribes what should be the minimum standards regarding how the premises should be, how the living condition should be, how the hygiene and cleanliness sanitation should be maintained, what should be the quality of food and water provided there, what should be the quality of social, cultural, leisure and recreational activities provided there, what should be the human resource requirement in any establishment, how much should be the medical and paramedical staff availability be there in that establishment, what should be the floor space, what about the equipments and articles, what are the methods used, alternate methods used to avoid restraint, and how the dignity, safety and security of the people with mental illness who are kept in that establishment are protected, and how this whole establishment should comply with the provisions in the RPWD Act. Coming to briefly, I want to mention what has been happening in Karnataka. State of Karnataka has already made this Karnataka State Mental Health Care Rules in the year 2021. We are making the State Mental Health Authority are making its own regulations, and which is under process. In the state, 2 mental health review boards have been constituted already, and it's actively working. We have also made a policy for care of homeless mentally ill, and it's with the government for consideration, and it can make a government order as to how this homeless mentally ill in the whole of Karnataka state should be managed. We have the government has initiated a committee for formulating guidelines for supported accommodation. This committee has been formed, and we are yet to start the deliberations. We have been conducting series of workshops for mental health establishments, caregivers, and ambulance staff to ensure that quality care is being provided for people with mental illness. I'm coming to the end of my presentation. I feel appropriate law is in place. This this act looks quite ideal, and it has actually initiated or created a lot of discontent among the medical practitioners, psychiatrists, because it puts a lot of hindrances to a normal functioning, which was happening all these years. Now we are accountable to various judicial bodies, statutory bodies, and a lot of registration processes, a lot of informing processes. All these have come. So psychiatrists feel probably all these were not necessary. However, this law is in place. And as I was mentioning, this is giving, putting so much of pressure on the government to provide various mental health services. Throughout our country, mental health was generally neglected. Now, with this particular act in place, no government can actually neglect mental health. People have rights to, people with mental illness have rights to get so many services, and the government has an obligation to provide all of this. So a good law is in place, but implementation is pending. In many states, authorities are not functioning, boards are not established, and public are not aware, patients are not aware. So implementation is necessary. All this implementation needs active participation of the caregivers and people with mental illness. As we all know, any act which is enacted doesn't get practically implemented overnight. It's a very slow process. It might take decades. However, this act gives so much of importance to psychiatry, importance to people with mental illness, that a societal change can actually happen. And I am hopeful that gradually it will happen. The last point is, this particular act is mandated by the UN regulations. So many countries have similar acts. Australia has, UK has, America has. However, our country is a unique country. the socio-cultural circumstances in which we live, our value systems, our cultural beliefs, our family structure are actually unique. This law may not be enough to a country like ours, which has its unique necessities. So while we attempt to implement this particular act, I guess newer models of care will have to be thought of, created, and should be practiced. With these words, I want to end my presentation. Thanks for patient hearing.
Thank you, sir, for the presentation. I think you have kind of succinctly summarized the most important messages that a caregiver or a family member should know as far as caring for a person with mental illness, what kind of care the government has to provide, what kind of care is available, what are the rights of people with mental illness, and what special provisions or novel provisions have been made in the Act. I think we will now open the forum for discussion and for questions. If there are questions in the chat, we may take that up to begin with till we wait people to unmute and ask questions.
Can I ask a question, sir? My name is Dr. Rajiv. Can
Yes.
I ask a question, sir?
Yes, sir. Go ahead, sir.
You were talking about the mental health establishment. What about the psychiatric consultation clinics and the counseling centers? Counseling centers, do they have to be registered, sir?
Sir, it's a question of interpretation. Some
Yeah.
people have tried to include the OP clinics and counseling centers also into this definition of mental health establishment. I
Yeah.
guess each state will have to take a call on this. As of now, in Karnataka, what we are following is only places where they are admitted, where they are kept overnight for whatever care and rehabilitation, they will be considered as mental health establishments. So in Karnataka, counseling centers are not considered mental health establishments.
Sir. Second question, sir. The advance directive. Now, how can a mentally unsound person give an advance directive? Because he's got hallucinations, delusions, he's paranoid. Therefore, in my understanding, the advance directive should be given when he is in a proper state of mind, which has to be certified by the psychiatrist that he is all right and he's given his advance directive in a proper state of mind. Isn't that important, sir?
Sir, this your question is very valid. A person is supposed to make a valid advance directive. Obviously, it doesn't mean that when he doesn't have capacity to understand his own illness, he cannot make an advance directive. However, if anybody feels that this particular advance directive was made in a state of illegally what is called unsoundness, that can be questioned in the mental health review board and that can be modified.
Right.
I'd like to ask a question. Rajiv Sikka here. I'd like to ask a question.
Please go ahead, sir.
Okay, my question is that this act was established in 2017, right?
Yes.
Now it's been 7 years, and don't you think it's high time that at least about 75 to 80% of the provision should have been implemented? Because in the meantime, the caregivers and the mentally disturbed person keep on suffering. The psychiatrists are only, my experience says that the psychiatrists are only interested in making money. The charges have gone through the roof, and the state governments have not stepped up their implementation plan. We cannot hang on in limbo for long after that. What do you think about this?
Yeah, I mean, I can't have an argument about it. It should be implemented, not even 8%, 100% should have been implemented. But as I said, mental health is a neglected subject throughout the country. So unfortunately, it has not happened. It must happen.
No, but sorry, but where is the accountability? Where is the accountability? Why aren't the people who are supposed to implement it being asked to give reasons to do so? I mean, the Modi government is very, very particular about accountability. So why is the PMO or somebody not taking action to take this thing in this critical area? I mean, just because it's not a vote bank, is that the reason?
Sir, I can't explain the delay of various state governments. Actually, it will not be implemented by the central government. Each state government has to do it. I can't explain why state governments are not doing it. However, if anybody is interested, they can actually file a PIL in the High Court asking this particular question as to why it is not implemented. And
Sir,
at least in Karnataka, it has happened. People have questioned the state
so
government
that is what I'm
in
saying.
High Court.
Karnataka seems to be way ahead. So why can't I don't know what the center or somebody step up this operation, because believe me, I mean, you say that we should file a PIL. हम केयर गिवर्स कहाँ PIL फाइल करेंगे? हमारे पास नॉलेज नहीं है, प्रोसेस नहीं है, सपोर्ट नहीं है. Tell me an organization which will help us people to file an PIL, and definitely I will go and file a PIL.
Sir, in
You know the
Karnataka, we
status of
have
the judiciary.
this Karnataka State Legal Service Authority. I am not aware of similar legal service authorities in other states. In Karnataka, free legal aid is available to everybody under this particular act.
So can somebody help me by giving me information whom I can approach for similar help which is being provided by the Karnataka people? I mean, Karnataka body. I stay in Delhi, and my sister is suffering day in and day out, and I have no recourse. You believe me, for the last 2 years, I've been going to the psychiatrist and going from pillar to post. I must have spent at least about 1 lakh, 1.5 lakhs on the payments with no result. Now, I know that schizophrenia cannot be cured, but help in terms of managing it, in helping out, is I'm not getting any help.
So I think you have an important point since you are living with the experience of facing challenges as far as personally taking care of your sister. I think you could write an email to us. We'll try to find out what is the status of legal support in Delhi, and probably we'll
Thank you
write
very
back to
much. Thank you very much. That is the response I was looking for. Thank you so much.
Krishna Prasad, may I ask you a question?
Yes, sir.
Dr. Kalyan Chandra.
Yes, sir.
Dr. It was a very useful presentation. I have a question. As most of you know, we are in an NGO called the Richmond Fellowship. And when we try to apply for renewal of our license for the short stay home, they're asking for a KPME certificate. Now, last time when we did apply for the long stay home, the process of getting a KPME certificate took nearly 1 year. Now, Dr. Prashant, could you tell us why KPME certificate is essential for a halfway home?
Sir, it's a tricky question. I don't know whether that comes into the
Okay.
the content or subject of this for today's.
I understand. Because you are available, I thought you may throw some light. Maybe I'll touch with you later.
Yes, sir. A personal call would be better.
Yes, I will certainly do the Dr. Prashant.
Sir, I think you have not had the provisions under the rules to apply as a halfway home. It is still as a mental health establishment that you have.
That is the point. The reason I ask this question is it is seen as a mental health establishment, doesn't satisfy all the requirements of mental health establishment. Yet all these years, we have been running it for more than 30 years. They never asked for this KPME certificate. This time, for the first time, they asked for the long stay home, and now they're asking for this. It's a huge process. We don't know what to do. We are stuck between two stools. But anyway, I think, I agree with you. It is not a forum for this, because the title of mental health establishment came into discussion. We thought we will get some answer. Dr. Prashant, I will get in touch with you and see how we can help or speed up the process that the time taken is reduced so that we get the process going. Thank you very
Thank you,
much.
sir. Thank you.
Harish has a question. Harish. Harish, you can unmute.
Yeah, sir, thank you for again narrating that crisp presentation. I was just I'm asking this question, which I heard from many caregivers, that what are the supports that are systems that are available for them when a person in family inside the house refuses to take treatment and indulges in some kind of activities which can fall under the rubric what we consider as a slow deterioration in kind of their self-help care, or it can be verbal violence, not to amount that to the destruction that what sometimes immediately people would be filing a police case kind of thing. In all such cases, whenever they try to bring them into the loop of treatment, they are not finding adequate support systems in the communities what they describe. Whether they go to a police station where they will be given some kind of circumstantial responses, or even they go to a psychiatrist or even government hospitals, the immediate reply would be patient has to be brought somehow. So sometimes they say that 108 may help them, may not help them. Now I'm just looking at when you mentioned about care by 2 certified doctors in the community. Now, does that open a window? Like, for example, if the family caregivers asks some kind of 2 medical officers, they pay them, who would come to home, who would certify that yes, this person is having mental ill. Now, can that overpower the autonomy of person who refuses treatment at home?
The care of people who are in prodromal state or early signs of who are showing early signs of relapse, it has been made very tricky and very difficult by this particular act. Each person, unless proved otherwise, is deemed to have the capacity to take care of his treatment and make his decisions. So, unless somebody really fulfills that criteria, only then others can take over. So, in a place where he has started neglecting his care, his self-care is not adequate, or he is having odd behaviors, but not bad enough to be gone, I mean, get taken up to police station. This particular act is silent about such situations. I can't provide any answer as to what is to be done. These 2 psychiatrists, as I understand, they should be psychiatrists attached with a mental health establishment. So, a person is brought to establishment, and then 2 psychiatrists examine him, and they certify that he needs admission. That's when it's going to happen. Your question of can 2 psychiatrists override the autonomy of the patient? Yes, if patient doesn't have capacity to make his own treatment decisions. That's how I understand the act.
We have also, I mean, since we have started the assisted home care services, we have had situations where families call us, but this gray area of capacity sometimes becomes a challenge to provide services. And I think Harish's question also stems from that difficulty sometimes where we do not know how really to help in such a situation. I don't know whether the mental health authority can help frame rules or can seek suggestions from the law department to deal with such situations, or write to the central government, whether there is so moto provision to write in such cases.
Yeah, I mean, authority has a responsibility to improve or maintain, specify, prescribe the quality of services provided in any state. So, situations like this where a person is not really too sick, but then he is on the way to become sick, what is to be done, which is not really mentioned in the act or not specified in the act, authority can really look into it. Make my effort.
Can I butt in, sir? Can I butt in? Here, the authority is the doctor. When there's a psychiatrist and when he's seeing that So he can take the call and he can put forward the papers and, influence the relatives that it is to be done, or else move the legal department into it. See, many times we take the call when the patient tells us what the patient wants to do, and the attendant is going against this. So we try to make them understand and talk on behalf of them. There has been several cases where I, as a GP, have gone and cremated my patient from the hospital. Now that apart, sir, one very interesting question. You said that if an unsound person in a mentally health establishment gives a complaint against a doctor or somebody, the mental health the board will decide what went wrong. Now, an unsound person is not able to have the correct judgment. So, how will you take his complaint in a proper frame of mind, sir? It could be now if I'm running a mental health establishment and somebody gives a complaint to you, a mentally unstable person, how can you go by his complaint? It's understand if it's a nominated representative with the complaint, yes, you can take it. But when a mentally unwell person and with a very major depressive disorder, how would you, or major psychiatric problem, how would you, what relevance could you give to his problem, sir? And you said you will be.
Sir,
inquiring.
I think this act came into vogue considering the fact that with the very important rights violations were happening in mental health establishments, and it is for the purpose of protecting the rights of persons with mental illness that this act came into vogue. So to assume that people with mental illness do not have the capacity to complain, understand the predicament that they are in, also would be an extreme position, sir. I think there have been real instances of abuse and real instances of challenges that persons with mental illness have faced. I think it is with the intention to protect. And I think the Mental Health Review Board has a representation from people of diverse backgrounds, including psychiatrists, judicial authorities, and family representatives. And I think they will take a reasonable call based on the and look at the genuineness of the complaint. So we should not assume. I think the very fundamental aspect of the act is that people should not assume that people with mental illness do not have the capacity to take decisions, or that their rights in any way can be infringed.
Even if it's schizophrenia, they have a right to make complaint. They have a right to those are the many rights I mentioned. Irrespective of their psychiatric status, each of them are eligible for that.
Okay, sir. Right, sir. Thank you, sir.
There are questions on the chat.
Hello, good afternoon, sir.
Yes, sir. Please.
Can I ask?
Yeah.
Yes, my name is Jaspal. I happen to be the father of a person 40 years old who is having schizophrenia for the last 25 years. Hello.
Yes, sir. Go ahead, sir.
Yeah, so we are settled in Bangalore, and we are senior citizen touching the age of 70 plus. So I think there was, likelihood of a designated authority by the government of Karnataka, whereby, the parents, they can approach and they can request and make an application for the, that appointing a legal guardian for the children. So it has started, or no, it is yet to start, sir?
Sir, I think the district courts have been designated to take up the issues surrounding guardianship, and we have had instances where people have approached the district court and obtained the guardianship.
Which electronic city? No, I mean, I am staying in Electronic City. So, I mean, if some kind of a guidance could be given how to proceed, because I'm not really aware about how to go about this.
You could, again, like I mentioned to Mr. Rajiv Sikkaji, you could write to us and we could provide you the details with regard to that.
Okay, thank you so much, Dr. Krishna Prasad. Thank you.
Dr. Harish also wants to add in. Please, Harish.
Yeah, sir, I think if I can add something in this line, one thing that you can consider is first obtaining a unique disability ID. So any person who has a valid benchmark disability certificate. Now the second legislation that comes into place is Rights of Persons with Disabilities Act. Under the Rights of Persons with Disabilities Act, District Commissioner chaired board can grant a limited guardianship or permanent guardianship certificate. So under Karnataka, these rules have come. So anybody who wishes to apply for legal guardianship for somebody who has a valid benchmark disability certificate, there is a format which is downloadable, or you can approach the district disability welfare officer. You can submit application in
Disability.
Disability Welfare Office, DDWO.
DDWO.
District Disability Welfare Office. This is also
Okay.
adjacent to Nimhans in Bangalore. So they can be approached, and application can be submitted, and then they will forward it to the periodical meetings conducted by the district collector, where these applications will be scrutinized and appropriate actions will be taken.
Okay. So this will be a LLC, huh? Limited period.
Initially, it will be given as a limited guardianship certificate for few years or for few areas, and subsequently the committee can take that, they can issue a plenary guardianship if needed.
Okay. Okay. Thank you. And whom should we write to?
Are you asking about
You
email,
could
sir?
No, you could write to our email ID, which
Okay.
Sneha madam will put it up on the chat box.
Okay, sir.
We will send
Okay,
you the relevant document.
Okay. Okay. Thank you, sir. Thank you, Dr. Harish. Thank you, Dr. KP. Thank you.
Good afternoon, sir.
Yes, please
Sir, myself
introduce.
Pramod Chikbalapur.
ಹೇಳಿ ಸರ್.
ಸರ್ ಕನ್ನಡ ಮಾತಾಡ್ಬೋದು ಸರ್?
ಮಾತಾಡ್ಬೋದು.
ಸರ್ ನಾವು ನಮ್ಮ ಸಿಸ್ಟರ್, ಸೊ ನಾವೊಂದು more than 15 years ಆಯ್ತು ಸರ್ ಬೈಪೋಲಾರ್ ಡಿಸಾರ್ಡರ್ ಇಂದ ಫೇಸ್ ಮಾಡಿ. ಸೊ ನಾವೀಗ ಟ್ರೀಟ್ಮೆಂಟ್ ಫಸ್ಟ್ ನಿಮ್ಯಾನ್ಸ್ ಅಲ್ಲಿ ತಗೊಂಡ್ವಿ ಸರ್ 2006 ಅಲ್ಲಿ. ಬಟ್ ಅದಾದ್ಮೇಲೆ ಸ್ವಲ್ಪ ನಮ್ದು ಎಕನಾಮಿಕಲಿ ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು ಸರ್. ಲ್ಯಾಂಡ್ ಇಶ್ಯೂ ಎಲ್ಲಾನು ಡಿಕ್ಲೇರ್ ಆಗಿಲ್ಲ. ಹಲೋ,
ಹೇಳಿ ಸರ್, ಮುಂದುವರಿರಿ.
ನಮ್ಮ ಫಾದರ್ ಈಗ ಅವ್ರಿಗೂ ಮ್ಯಾಕ್ಸಿಮಮ್ 75 years ಏಜ್ ಆಗಿದೆ ಸರ್ ಅವ್ರಿಗೂನು. ಅದು ಏನಾದ್ರು ಲೀಗಲ್ ಆಗಿ ಏನಾದ್ರು ನಾವು ಇದ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಸರ್? ಈಗ ಇಲ್ಲೆಲ್ಲ ಲ್ಯಾಂಡ್ ವ್ಯಾಲ್ಯೂ ಎಲ್ಲ ಜಾಸ್ತಿ ಆಯ್ತು ಸರ್, ಯಾರು ಕೇಳ್ತಾ ಇಲ್ಲ. ನಮ್ಮ ಅಂಕಲ್ಸ್ ಅವರೆಲ್ಲಾನು ಅವ್ರದ್ದೇ ಆದ ಇದ್ರಲ್ಲಿದ್ದಾರೆ. ಏನಾದ್ರು ಲೀಗಲ್ ಆಗಿ ಏನಾದ್ರು ನಾವು ಈ ತರ ಆಪ್ಷನ್ ಇದೆಯಾ ಸರ್? ನಮ್ಗೆ ಈ ಕಡೆ ಏನಂದ್ರೆ ಜೀವನ ಮಾಡದೆ ಕಷ್ಟ ಆಗಿದೆ ಸರ್. ಆ ಕಡೆ ಹಾಸ್ಪಿಟ್ಲದು, ಈ ಕಡೆ ಮನೆ ಖರ್ಚು, ಅದು ಇದು, ಈ ಕಡೆ ಸರಿಯಾಗಿ ಮಳೆ ಇಲ್ಲ, ಬೆಳೆ ಇಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು ಗೊತ್ತಾಗ್ತಿಲ್ಲ. ಹಂಗಾಗಿ ಸ್ವಲ್ಪ ತುಂಬಾ ಕಷ್ಟ ಆಗಿದೆ ಸರ್.
ಅಲ್ಲ, ಸಹಾಯ
ಏನಾದ್ರು ಆತರ ಆಪ್ಷನ್ ಇದೆಯಾ ಸರ್?
ಲೀಗಲ್ ಯಾವ ವಿಷಯಕ್ಕೆ ಬೇಕಾಗಿರೋದು?
ನಮ್ದು ಲ್ಯಾಂಡ್ ಡಿಕ್ಲೇರ್ ಆಗ್ಬೇಕು ಸರ್. ಲ್ಯಾಂಡ್ ಇದೆ ಸರ್, ನಮ್ದು ಒಂದು 16 acre ಲ್ಯಾಂಡ್ ಇದೆ ಸರ್. ನಾವು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಸರ್, ನಮ್ದು 4-5 ಮೆಂಬರ್ಸ್ ಇದೀವಿ ಸರ್. ನಮ್ಮ ಅಂಕಲ್, ನಮ್ಮ ತಂದೆಯವರು ಎಲ್ಲಾರು ಜಾಯಿನ್ ಇದಾರೆ. ಸೊ ಅದು ಏನಾದ್ರು ನಾವು ನಮ್ಗೆ ಈ ತರ ಕಷ್ಟ ಆಗ್ತಿದೆ, ನಮ್ಗೆ ಏನ್ ಭಾಗ ಬರುತ್ತೋ ಅದ್ ಕೊಟ್ರೆ ಸಾಕು ಸರ್. ನಾವೇನ್ ಜಾಸ್ತಿ ಕೇಳಲ್ಲ ಸರ್ ಅವ್ರನ್ನ. ಕೋರ್ಟ್ ಇಂದ
ಅಲ್ಲಲ್ಲ, ಅದು ನಿಮ್ಮ ತಂಗಿ ಪರವಾಗಿ ನೀವು ಕೇಳ್ತಿರೋದು ಅದರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ.
ನಮ್ ತಂದೆ ಪರವಾಗಿ ನಾನ್ ಕೇಳ್ತಾ ಇದೀನಿ ಸರ್.
ನಿಮ್ ಮಾನಸಿಕ ರೋಗ ಉಳ್ಳವ್ರು ಯಾರು?
ನಾನು ನಮ್ಮ ಅಕ್ಕ ಸರ್.
ನಿಮ್ಮ ಹಕ್ಕುಗಳನ್ನ ನೀವು ಪಡ್ಕೋಬೇಕು ಅಂತ ಕೇಳ್ತಿರೋದು?
ಹೌದು ಸರ್. ಈಗ ನಾನು ಮದ್ವೆ ಆಗಿದ್ದೀನಿ ಸರ್. ಅವ್ರು ನೋಡಿದ್ರೆ ಅದೇನ್ ಮಾಡ್ಕೊಂತಿರೋ ಮಾಡ್ಕೊಳ್ಳಿ, ನಾವು ಯಾವ್ದೇ ಕಾರಣಕ್ಕೂ ನಮಗ್ ಬೇಕಿಲ್ಲ ಅಂತ ಅವರು ನೆಗ್ಲಿಜೆನ್ಸಿ ಮಾಡ್ತಾವ್ರೆ ಸರ್. ಸಪೋಸ್ ನಾನು ಆಲ್ರೆಡಿ ಟೂ ಟೈಮು ಮಿಸ್ ಆಗಿದೆ ಸರ್. ನಾನು ಸಿಕ್ಕಿದ್ದೆ ನಮ್ಮ ತಂದೆ ತಾಯಿ ಅದೃಷ್ಟ. ಅವ್ರೇನೋ ಯಾರೋ ಸಿಕ್ಕಿದ್ರು ಕರ್ಕೊಬಂದು ನನ್ನ ಮನೆಗೆ ಒಪ್ಸಿದ್ರು ಸರ್. ತಿರ್ಗಾ ನಾನು ಈಗ ಏನಾದ್ರು ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗಿ ನಾನು ಸಪೋಸ್ ಮಿಸ್ ಆಗ್ಬಿಟ್ರೆ, ಸೊ ನನ್ನ ಹೆಂಡತಿ ಬೇರೆ ಇದ್ದಾಳೆ ಸರ್. ಅವ್ರ ಜೀವನ ಏನಾಗ್ಬೇಕು? ಅವ್ರಿಗೆಲ್ಲ ಮೋಸ ಆಗೋಗ್ಬಿಡುತ್ತೆ. ಲಾಸ್ಟ್ಗೆ ಅವರು ಬೀದಿಗೆ ಬರ್ಬೇಕಾಗುತ್ತೆ ಅನ್ನೋದೊಂದು ಭಯ.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿ ಅವರ ಕಡೆಯಿಂದ ನೀವು ಫ್ರೀ ಲೀಗಲ್ ಏಡ್ ಪಡೆಯೋ ಹಕ್ಕು ನಿಮಗಿದೆ. ಅವರನ್ನ ಅಪ್ರೋಚ್ ಮಾಡಬಹುದು ಚಿಕ್ಕಬಳ್ಳಾಪುರದಲ್ಲಿ.
ಸರಿ ಸರ್. ಚಿಕ್ಕಬಳ್ಳಾಪುರದಲ್ಲಿ ಅವ್ರ
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿ.
ಓಕೆ ಸರ್. ಸರಿ ಸರ್. ಅವ್ರ ಮುಖಾಂತರ ನಾವು
ಏಡ್ಸ್ ಮಾನಸಿಕ ರೋಗ ಇದ್ದಲ್ಲಿ ಡಾಕ್ಟರ್ ಹರೀಶ್ ಹೇಳಿದಾಗೆ ನಿಮ್ಮ ಹತ್ರ UDAD ಕಾರ್ಡ್ ಇದ್ದಲ್ಲಿ ನಿಮ್ಗೆ ಸುಲಭ ಆಗಬಹುದು
ಸರ್. ನಾನು ಸ್ಪಂದನದಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂತಾ ಇದ್ದೀನಿ ಸರ್ ಅಲ್ಲಿ.
ಅಲ್ಲ, ನಿಮ್ಮ ಮಾನಸಿಕ ರೋಗ ಅಂಗವಿಕಲತೆಗೆ ಅಂಗವಿಕಲತೆ ಬೆಂಚ್ ಮಾರ್ಕ್ ಮಟ್ಟಕ್ಕೆ ಇದ್ದರೆ ನಿಮಗೆ UDID ಕಾರ್ಡ್ ಸೌಲಭ್ಯ ಸಿಗ್ಬಹುದು. UDID ಕಾರ್ಡ್
ಅದು UD ಕಾರ್ಡ್ ಅಂದ್ರೆ ಯಾವ ತರ ಸರ್ ಅದು ಕಾರ್ಡ್?
ಅದು ನೀವು ಅಪ್ಲೈ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ನೀವು ಅಪ್ಲೈ ಮಾಡೋದಕ್ಕೆ ನಿಮಗೆ ಕಂಪ್ಯೂಟರ್ ಸಲಕರಣ ಅಥವಾ ಇನ್ನೊಬ್ಬರ ಸಹಾಯ ಬೇಕಾಗಬಹುದು, ಅಥವಾ ನಿಮ್ಮ ಜಿಲ್ಲಾ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿ ಅದನ್ನ ಮಾಡಿಸ್ಬೋದು.
ಸರಿ ಸರ್.
ಅದಾಗದಿದ್ದಲ್ಲಿ ನೀವು ನಿಮ್ಹಾನ್ಸಿಗೆ ಬಂದು ಕೂಡ ಮಾಡಿಸ್ಬೋದು, ಅಥವಾ ಬೆಂಗಳೂರು ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ಅಲ್ಲೂ ಕೂಡ ಮಾಡಬಹುದು. ವಿಕ್ಟೋರಿಯಾ ಆಸ್ಪತ್ರೆ.
ಸರ್ ನಂದು ಮೋರ್ ದನ್ 5 ಎಲ್ಲ ಇದೆ ಸರ್. 17 ಇಯರ್ಸ್ ಆಯ್ತು ಸರ್. 2006 to 2024ಗೆ 17 ಇಯರ್ಸ್ ಆಯ್ತು. ಅಲ್ಲಿಂದ ಟ್ರೀಟ್ಮೆಂಟ್ ಅಲ್ಲೇ ಇದ್ದೀನಿ. ಬಟ್ ಒಂದು 3 ಟೈಮ್ ಆದ್ರೂ ಮಿಸ್ ಆಗಿ ಏನೋ ಅದು ಇದಾಗಿ ಈಗ ರಿಕವರ್ ಆಗಿದೀವಿ ಸರ್. ನಾನು ಆಗಿದ್ದೀನಿ, ನಮ್ಮ ಸಿಸ್ಟರ್ ಆಗಿದ್ದಾರೆ. ಬಟ್ ಏನಂದ್ರೆ ನಮ್ಗೆ ಜೀವನ ಈಗ ನಡೆಸ್ಬೇಕಂದ್ರೆ ಏನೋ ಒಂದು ಮನೆ ಕಟ್ಟಕ್ ಆಗ್ತಿಲ್ಲ, ಒಂದ್ ಸೈಡ್ ತೆಗಿಯಕ್ ಆಗ್ತಿಲ್ಲ, ಎಲ್ಲರ ಜೊತೆ
ನಿಮ್ಮ ಹಕ್ಕುಗಳನ್ನ ಕೇಳೋ ಅಧಿಕಾರ ನಿಮ್ಗೆ ಎಷ್ಟರ ಮಟ್ಟಿಗಿದೆ, ಮತ್ತೆ ನಿಮ್ಮ ಆಸ್ತಿಯಲ್ಲಿ ನಿಮ್ಗೆ ಎಷ್ಟು ಅಧಿಕಾರ ಇದೆ, ಅದನ್ನ ಹೊಂದ್ಕೊಂಡಿದೆ. ಅದನ್ನ ನೀವು ಲಾಯರ್ ಮುಖಾಂತರ, ಲೀಗಲ್ ಏಡ್ ಮುಖಾಂತರ ಪಡಿಬಹುದು.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Two independent practitioners.
There is a question by Ms. Apurva. Do independent practitioners who have RCI license, clinical psychologists or special educators have to register their practice somewhere like mental health establishments? Now, mental health professional, not practitioner, mental health professionals need to register according to the Act under State Mental Health Authority. Special educators are not into this. Clinical psychologists with RCI will have to register. If so, and they don't have to be attached with any mental health establishment per se. They can have their private practice. However, just to have a database, each authority is supposed to maintain this list of mental health professionals. If so, in case the practitioner hires other mental health professionals to constitute an organization, what is the protocol? I'm not clear what is the second part of the question. The practitioner has a right to hire other mental health professionals, and those professionals also will have to be registered. In Karnataka, the psychiatrists are also supposed to register. Generally, the Act keeps psychiatrists out. Otherwise, psychiatric social workers, psychiatric nurses, psychiatrists, clinical psychologists are supposed to get registered. This question has already been answered. Advance directive needs to be registered with SMHE. I didn't understand. Actually, it is Mental Health Review Board. In Karnataka, where is the Mental Health Review Board operates? It is the office. It has an office in Nimhans. So people can come into hospital, Nimhans campus, and approach the Mental Health Review Board. Does an individual have? Further, several states do not have mental health review boards. What should people do? You will have to wait until the governments establish mental health authorities, and mental health authorities in turn establish the mental health review boards. These advanced directives will have to be registered under mental health review board. Unsound mind is a legal term, cannot be equated with mentally unwell. Unsound declaration can be done only by the court, not by anyone else. I totally agree with that. Yeah, this is also answered. This
and the
providing.
Somebody has raised that.
Mr. Rajiv Sikka.
This you can answer.
Sorry, can you? I have one question.
Yes, sir.
Hello. I'm a caregiver for my sister. She is 57 years old. Do I need to get legal guardianship for her?
It is a choice that you have to make, whether you want to take legal guardianship or not. There is a provision for legal guardianship under the Rights of Persons with Disability Act.
So maybe I'm trying to ask, under what circumstances is it required for the guy? I mean, I can carry on taking care of her. Is there any requirement or stipulation that I should take guardianship?
There is no
Any-
mandatory requirement, but if for any legal reasons you wish to take, then you may wish to take the guardianship. Very often there are situations where there can be legal issues that crop up because of the kind of relationship one has with the family member. You may
For
wish to do
example?
that. It can be disputes,
Okay.
or it can be in circumstances where financial implications are there.
Right.
So that is where probably it would be safer to have legal guardianship.
Okay. Thank you.
Otherwise, if there are no such issues, people may not opt also to take legal guardianship.
Okay. Thank you, sir. Thank you.
So one question, sir. I have a individual in my society who's a sick person, and he creates a lot of problems to the neighborhood. I knew him for many years. He was a normal boy, chartered accountant. I knew his father. I was a physician to his father. He's no more. The people around the place know that he's mentally unwell. There are two brothers. Both of them are mentally sick. One is stabilized with medicines. The other one is not. What is my role in this given scenario? Can I give a deaf ear? Can I inform the police about it? That this is the situation, and involve the police to take him to the hospital. He refuses to take his brother's advice. Now, do I have any role to play here at all, or just keep quiet? Your advice, sir.
Sir, it depends on the initiative that you can take. As a well-wisher, if you want to intervene, the path would be that either you can convince that boy to take help. If
Not
that
possible,
is not
sir.
possible,
Not possible. Yeah.
if that is not possible, according to the act, the other part of the other person in authority would have to be police. You will have to involve them, and you have a right to complain to the police that he is being ill-treated or neglected by the family, if that is so, or else also that he is dangerous to himself or dangerous to others. You can definitely report to them.
Thank you, sir. Thank you, sir. Thank you very much. Thank you.
I think, yeah.
There's a comment that Mental Health Care Act is really only on paper, not yet operational. At least in Karnataka, it is not so. All aspects of the act are being, to the maximum extent, attempts are being made to be implemented. And who has the priority for legal guardianship?
I think it is for the board to decide depending on the circumstances. I don't think there is a categorical answer to that. It is for the board to decide.
Good afternoon, sir.
Yes.
Yes.
This year नेशनल ट्रस्ट में मेंटल इलनेस इंक्लूड है या नहीं, आप प्लीज कंफर्म करेंगे?
नेशनल ट्रस्ट एक्ट में मेंटल इलनेस इंक्लूडेड नहीं है. उसमें इंटेलेक्चुअल डिसेबिलिटी, ऑटिज्म, सेरेब्रल पैल्सी और मल्टीपल डिसेबिलिटीज इंक्लूडेड हैं. मेंटल इलनेस उसमें नेशनल ट्रस्ट एक्ट के अंदर नहीं आता है, उसके अंतर्गत नहीं है.
But it should be there ना, मेंटल इलनेस नेशनल ट्रस्ट में होना तो चाहिए मेंटल इलनेस का प्रोविजन.
नेशनल ट्रस्ट एक्ट बना था शायद 1999 में, तो तब की परिस्थितियों के अनुसार ये बनाया गया था. अगर इसमें कोई तब्दीली लानी है तो शायद आपको या जो भी कंसर्न है लिखना पड़ेगा नेशनल ट्रस्ट को। और जहां तक मेरी जानकारी है यही इन 3-4 समस्याओं के लिए ये सीमित है नेशनल ट्रस्ट एक्ट। और चूंकि मेंटल इलनेस के लिए एक सेपरेट एक्ट है तो कितना ये नेशनल ट्रस्ट एक्ट के अथॉरिटीज इसको लेंगे ये उन पर निर्भर है। Shiva, you have a response to that? Shiva? Dr. Shiva Kumar had raised his hand. I think he's not there. No?
Hello.
Yeah, Shiva, please go ahead.
I just want to respond to your question on National Trust Act. So I think there are places where the National Trust Act is functioning, but the local guardianship, I think that board has not been clearly formed. So there is a Madurai High Bench of the Madurai High Court, where a judge has given a ruling that people be given guardianship under National Trust Act. But there is a judgment which says that the local level committee under National Trust Act can issue guardianship because someone applied that there is no other thing, then how do we go about? So there is some precedence there. So even though it is not in keeping with the spirit of the act. And coming to the second thing of like who can actually give be the guardians. So it depends on the discretion of the local state. So at least in the state of Karnataka, I think we have certain guidelines. I'll just open it. It actually specifies like who are the people, which actually includes it can be the blood relative or it can be the head of the institution where that person actually stays. So maybe I'll just read it out. So it specifies, of course, the board, whomsoever is granting it, they will consider. So the first category is parents or adult children or spouse. The second category is immediate brother or sister. The third is blood relatives or caregivers or prominent personality. The fourth category is head of institution where the person with disability is under care. So
I think
this is the guideline which is given.
Yeah, I think that question was between parents and spouse. I think it can be tricky, and I think that is why probably the board's understanding of the circumstances will decide who may be given priority. There may be situations, I think, where dispute is likely to be there. And I think that is
in
why,
such cases, usually the sibling, the spouse actually has the upper hand.
And so, but then I think that the board decides, no?
The board actually does not decide. They say that the spouse will give, but if the parents want, we have faced that kind of situations.
That is
so
in the
generally
local level
the approach
committee.
is,
That is in the local
in
level.
the local level committee, we have seen that kind of instances. So because the other person sends it to the local level committee, they say that you give a certificate. We say that like only that other person is eligible when the spouse is alive and the marriage has not been declared null and void. It is difficult for us to give it to the parents.
You're right. Yeah, legally it is
The
like
parents
that.
cannot
Right,
apply and then get the guardianship.
Yeah.
We do not have any
cannot.
locus standi to decide who is correct.
Yeah.
So
Yes,
the
you're
board
right, you're
usually desists from taking
Making
any
such
such decision in such cases.
You're right. Legal binding is there. You're right, sir.
So sister को तो legal guardianship हम कर सकते हैं ना, parents हैं हम, क्योंकि PMI is unmarried.
सिस्टर को कर सकते हैं.
हाँ हाँ, अपने लाइफ टाइम में हम कर सकते हैं डॉटर को, ब्रदर, उसके ब्रदर के लिए
सिबलिंग गार्डियन बन सकता है, भाई या बहन गार्डियन बन सकता है.
ठीक है, थैंक यू.
As far as husband is alive or wife is alive, when marriage is in place, then nobody else can be the guardian. The marriage has to become null and void. Here, if it's not married, it doesn't matter. There's no problem. There's no problem.
Sibling should be in Indian only, no, sir?
Sibling
This is-
has to be an Indian.
Indian citizen. I think we've
Yeah,
had
yeah,
it.
this is only
Indian
Indian
citizen.
law. This is the Indian law. This is the Indian law, Indian citizens. In the Marriage Act, after marriage, the right for everything is mutual in wife and husband. That is a standing law standing.
No, guardian
Legal
has to be an
standing.
Indian citizen.
Yeah.
Okay, I think I think Shiva has made an important point that the person with mental illness has a say. Nothing is done against the wishes of the person with mental illness. So I think that's
No,
an important fact.
he is not able to decide. इतना उसका awareness नहीं है, insight नहीं है, तो हम sister को guardianship कर सकते हैं ना?
सिस्टर को कर सकते हैं, बट उनके विशेष को भी कंसिडर करना जरूरी है, ये शिव कुमार जी कह रहे हैं. शिवा, डू यू वांट टू रिस्पॉन्ड टू दैट?
Usually what happens is the person should agree that this person can be my guardian. If the person says that I don't want this person, I don't trust, then you cannot do.
No.
Okay. तो उसके जो brother PMI है, उसको तो इतना insight है ही नहीं. He is not able
No,
to
I think
take.
these are things which we cannot sort out in online program. वो जो आपकी मतलब वो पेशेंट है, उनका स्थिति क्या है, वो दवाई ले रही है, ठीक है कि नहीं है, तो वो सब चीजों पे डिपेंड करता है. तो गार्डियनशिप में बस इतना ही अस्यूम करते हैं कि मरीज वो ठीक हो गया है, तो उनका ख्याल रखना है. जो उनको ठीक लगता है, हाँ इनसे मैं सहमत हूँ, मैं खुश हूँ, तो वही मतलब गार्डियन बन सकते हैं. तो आपके डॉक्टर से और लोगों से आपको बात करना पड़ेगा. तो इस सेशन में इसके बारे में मतलब चर्चा करना वो ठीक नहीं रहेगा.
अच्छा.
Yeah, I think since we are closing, nearing 3:30, we will close the discussion. I think we've had a very interactive discussion today. So I'd like to thank Dr. Prashant on behalf of Psychiatric Rehab Services for taking time to join us for the discussion around the Mental Health Care Act and its relevance to our caregivers. I think it has been a useful exercise. A couple of you have also expressed a desire to know more information. So we have provided our email ID on the chat box. You could write to us and we would provide you information to the extent that we are able to obtain and we are able to provide you. So thank you very much once again for joining. So it's close.